Welcome to Public Forum, a community outreach program produced at North Idaho College on the shores of Lake Coeur d'Alene. Featuring guests from around the globe addressing a wide variety of subjects, Public Forum serves to educate and enlighten. Please join host and moderator, political scientist Tony Stewart, in welcoming today's guest.
I would like to welcome all of our viewers to the North Idaho College Public Forum. And with this 12th week of our special series on confronting hate, humanity's greatest challenge, we shall end the 12-week series and next week move to a different topic. On this program, we again are using a different format than we normally use. We're going to be taking excerpts from a panel discussion that took place at Gonzaga University, which is one of the two campuses for the North Idaho College Popcorn Forum this year on confronting hate. The title of this panel discussion is The Use of the Courts to Combat Hate. And there are three members of this panel that are very distinguished in their fields. First of all is Mark Potok, who is the editor of the Southern Poverty Law Center's Intelligence Report. The second panelist is Professor George Critchlow of the Law School at Gonzaga University. And the third panelist is Norm Gissel, an attorney in Coeur d'Alene. He, along with Morris Dees of the Southern Poverty Law Center and Ken Howard from Idaho, were the successful attorneys for the plaintiffs in the case of the Keenans versus the Aryan Nations. All of these three people are very experienced in addressing how you do use the courts to combat hate, with that case being a very, very clear example of how plaintiffs can receive relief in civil court when they have been a victim of hate. Again, all three panelists will be discussing this question, and as I've indicated, it lasted 90 minutes, and we'll be taking excerpts from about 25 minutes of that program. We hope you will find this program as informative as we believe it was. And now, ladies and gentlemen, let me introduce to you the panelists, Mr. Potok, Mr. Gissel, and Mr. Critchlow.
It's a pleasure and an honor to introduce some of our three panelists today. Starting on my far left is George Critchlow, Associate Professor and Director of Clinical Programs here at Gonzaga University School of Law. He has been at Gonzaga since 1980 and is the former director and founding member and current board member of the Gonzaga Institute for Action Against Hate. He is a former member of the board of directors of the Washington ACLU, a former Fulbright professor at the University of Sibiu in Romania, and has been a longtime teacher of human rights. To George's right is Mark Potok, Director of Publications and Information for the Southern Poverty Law Center in Montgomery, Alabama. Mark tells me that it is indeed a challenge to fly from Montgomery to Spokane. Mark oversees the center's Klan Watch project and has done extensive research on the Ku Klux Klan. The Southern Poverty Law Center, we'll hear us abbreviate this, SPLC, quite a bit, I'm sure, is a nonprofit organization that combats hate, intolerance, and discrimination through education and litigation. He is a frequent featured guest speaker on the issue of civil rights and hate crimes. And on my immediate left is Norm Gissel, attorney of law who practices in Coeur d'Alene, Idaho. He has been a key participant in the Kootenai County Task Force on Human Relations and has teamed over a span of 2 decades with Tony Stewart and the late Bill Wasmuth, along with other members of the task force, when they more or less have written a manual on how local communities should respond to hate groups such as the Aryan Nations. Norm was the attorney for Victoria and Jason Keenan. You may be very familiar with those names, who were the recipients of a $6.3 million judgment against the Aryan Nations. And Norm, in his wisdom, enlisted the help of the SPLC's Morris Dees in that famous case. So without further ado, I'm going to turn it over to our panelists, and we'll start with George and work this way, and they'll tell you their view of their role in combating hatred through the courts. George.
Thank you. Appreciate those introductions. I, unlike the Southern Poverty Law Center and unlike Norm, have never been involved as a litigant directly in a modern so-called hate crime trial or case. My experience rather comes from more traditional kinds of civil rights cases involving discrimination in the employment or the public accommodation or prison kinds of setting rather than, criminal kinds of actions. But I do think, in a broad sense, the courts have an enormous role in establishing and developing the law as it relates to hate and bigotry and discrimination, and also in reinforcing simply the notion that this is a country that's based on the rule of law. It's a country that stands for equal rights and equal opportunity, and it's a country that's willing to put its justice system where its mouth is, so to speak, in the sense of meting out consequences and punishment when perpetrators either violate the criminal law based on hateful conduct that can be constitutionally criminalized, or based on conduct which violates our civil rights. There's three kinds of ways that the courts can be involved and have an important role in this. One is simply the traditional civil rights kinds of cases where people go to court in order to vindicate the opportunity of victims of discrimination to be treated fairly and justly and with equal opportunity in the workplace, by employers, by businesses, in the context of public accommodations, in the context of housing, and that sort of thing. I think that that's very important, and that is about hate. Some discrimination is simply accidental or negligent or a result of stupidity or inattention. But a lot of discrimination is artfully cloaked, and it is intentional, it is conscious, and it is intended to hurt. So the traditional civil rights kinds of discrimination cases are important to keep employers and business and those who control public accommodations honest, and to make them pay so that there's an incentive not to continue that kind of conduct in the future. Whether or not the mind changes, I think the economics and the pocketbook of any situation will provide incentives for people to follow the law. The second kind of way that the courts are important in contributing to this is through tort actions and civil cases that are predicated on more modern so-called hate crime statutes. And these are the kinds of things that the Southern Poverty Law Center has engaged in and utilized effectively in the context of going after the Ku Klux Klan, Tom Metzger in Oregon, and more recently the Aryan Nations here in North Idaho. And those are very important, not only in the respect that it targets and reduces or diminishes the effectiveness of hateful individuals and organized hate groups, but symbolically that's important because it sends a message throughout the region and the country that there are people monitoring this activity and willing to aggressively respond to it. The third way that courts can be important is through the prosecutors, through the criminal courts, where prosecutors can either utilize traditional criminal law or more modern hate crime kinds of laws, including Washington State's malicious harassment law, to again symbolize society's commitment to stand behind the notion of the rule of law and equal rights and justice and equal opportunity. And I might anticipate one of the questions by saying, in general, I believe in hate crime laws, even though a lot of people argue that traditional criminal law already addresses the kinds of problems that most hate crime law also addresses. I think hate crimes are different in the sense that hate crimes typically, and this isn't original, I mean, most people who comment on this say the same thing, and I happen to believe it's true. Hate crimes are an effort to intimidate not the individual victim of the crime, but an entire group, an entire community, so that those people in that community fear engaging in society in a normal sort of way. It's to intimidate people, to make people operate out of fear, and to make it less likely that people are willing to assume their full and rightful role in civil society. And I think that kind of behavior, because it affects an entire group and is intended to attack an entire group, justifiably can be punished by special laws and with heightened or enhanced kinds of punishments.
Okay, and Mark?
I should say explicitly, I'm sure everybody here realizes that I'm not an attorney. I'm not a lawyer. I have no legal training. I wanted to just say a couple of things. One is that, of course, we've done all kinds of cases over the years, and a lot of them had to do with voting rights. A lot of them had to do with poverty issues. The kind of case I think of is a case we brought where, this was many years ago, over 20 years ago, where the state of West Virginia actually taxed a miner with a miner's pickup truck at a higher rate for more total dollars than many of the mining companies which owned concessions covering, tens of thousands of acres of land. So we did a lot of that kind of fairness litigation. Some of the early cases that we did also, as I said, had to do with voting rights. We brought a very successful case against the Alabama State Troopers, who were lily white, 100% white at the time the case was brought. And ultimately, although the thing dragged on for an amazingly long time, the Alabama State Troopers agreed to a consent decree whereby they would hire minorities until they were 25% black, which they are today. It makes them the highest, proportionally highest number of minorities in the troopers. What I really want to talk about, though, and I think what people are really interested in is, briefly, is our litigation against hate groups. And really, there's one main point I want to make, which is that, I remember we finished a similar case to the Aryan Nations case against the Christian Knights, the Ku Klux Klan, South Carolina and North Carolina. I remember the Washington Post wrote a lead on their story reporting on this thing, which actually, made the front page of the Washington Post. Something about the jury had decided that the leader of this group, Horace King, had created an atmosphere of hate, which had led to the burning of a church. And that's what the litigation was about, the burning of a church called the Macedonia Baptist Church. It really could hardly have been more wrong. The reporter, he's a perfectly intelligent guy, had completely misinterpreted the case. Let me talk about specifically Aryan Nations. I think, many times we are accused of essentially bringing cases on the basis, they're kind of speech cases. We don't like what you say, we're going to file a suit against you and, kind of make you take it back, make you pay. I think that is really clearly not what happened in the Aryan Nations case, and it's a very good example. I think the best analogy, or maybe just the simplest one, I'm sure it can be corrected by all the lawyers around me, is it really was a straight-up negligence case, and it seems to me that the analogy is to a department store that hires a driver that delivers stuff to your house, that has a fleet of drivers that that delivers this stuff, and the department store knowingly allows a guy who is a chronic drunk to drive one of these trucks. Ultimately, it's no surprise when that person runs into a crowd of school kids waiting for the school bus and, kills a bunch of them. That was really what that case was about. I mean, we were saying, Norman and SPLC were saying that Richard Butler went out, he hired people who were utterly untrained, offered them no kind of instruction in how they were to be security guards, quote unquote, guarding this compound, kind of armed them to the teeth, whipped them up into a frenzy with, the Jews are coming, and in no way ever tried to set any kind of policy. And that really was the basis of the case, that it was gross negligence on the part of Butler to engage in all these kinds of activities, and that what actually happened to Vic Keenan and her son was a foreseeable result of that kind of negligence. Some of the other cases are quite different. I would say, again, speaking as very much as a non-specialist, that the Christian Knights case I referenced just a minute ago was really a kind of civil conspiracy case. Horace King, the Klan leader in South Carolina, what he had told people around him was he talked about the quote-unquote nigger church down the road repeatedly, and he had talked about the fact he'd never actually asked someone to go out and burn the church, but he talked about how much he hated them, how good a thing it would be if that church were no longer around, and then had gone on to say in very unveiled terms that were somebody to burn that church down, he, Horace King, was quite capable of protecting that person from the law, that he was sure and he could ensure, in fact, that that person would never go to prison. One other thing I want to say about the case, is not to take up really any more time, is that and maybe Norm can, has some idea of this as well, is that I think our cases are very much more based than, say, on these kind of speech issues. They're very much based on investigative work. I think, as I kind of look at our own cases, I see how really heavily we investigate these. And so a lot of the work, it's not only lawyering. In my department is a guy named Joe Roy, who's a former homicide detective, and really one of the classiest investigators out there. And Joe is the person who went out and found just an incredible amount of stuff. I mean, we had stuff that I saw in the Aryan Nations case that never made it to trial. I remember, I don't know if Norm ever saw it. I'm sure he probably did. But I remember looking at a video of a bunch of the Aryan Nations guys standing around one day when a helicopter comes kind of thumping overhead. And they start to talk about how this helicopter is somehow associated with ZOG, the Zionist-occupied government or Zionist occupation government. And there's kind of some joking. And then one of the guys says to another, why don't we take a shot at it? And there's this kind of odd little discussion back and forth between them. And ultimately, it seems like manna from heaven to any lawyer pressing this case. They said, well, let's ask the pastor. And the camera turns, and they actually turn to the pastor and say, well, Richard, Pastor Butler, should we shoot at it? And he says, yeah. And then the camera follows the guy as he shoots a few shots into the air, and off this helicopter goes starring off and is not hit. I think that the stuff that Joe found was so good that because that was a little old, it dated back a few years, they didn't even use that. So I just want to make the point that, there's something more to it than simply going into the courtroom and saying, these people say vile things and somehow encourage their people to go on to commit criminal acts. As I said, in the Christian Knights case, it really was essentially a conspiracy case. I'd like to talk about other things, but I guess we'll get to it later, about hate crime penalty enhancement laws, for instance. I agree as a general matter on hate crime penalty enhancement laws that they're probably a good thing, although I think, we've had a lot of internal discussions about that. And let me simply say that I think that at least down there at SPLC, we've pretty much come to agree that there's really not much evidence at all to suggest that hate crime penalty enhancement laws prevent hate crimes. I think that's probably false, or if it's true to such a tiny degree that it's almost irrelevant. But I do think that it's a way of saying, it's really a kind of statement. It's a way of saying as a society just what George Critchlow just said, which is that, these are crimes that really have way more victims, many more victims than your, kind of garden variety assault, say, on somebody. So I think that really makes a difference.
Well, thanks, Mark. Norm, it's your turn now.
I'll certainly answer any questions you may have about the trial, mechanistically about what went on in the trial and why things were done in a particular way. I'd be happy to address those questions. But I want to talk about something that Mark said in his statements about the Klansman who said, who had rid me of this damn church, essentially, and that if it were burned down, the perpetrators could be protected by me. This is a classic Klan mentality, and one of the requirements of the Klan to exist in a society for any length of time is the ability to commit crimes without prosecution, and that was what Mr. King was referring to when he said he could prevent these people from being harmed by the judicial process once they burned the church down. We tried this lawsuit as a classic negligence case. Mark's exactly right. Richard Butler and the local Nazis tried this case as a referendum on their belief systems. It became, in a way, an up or down popularity contest. They believed, as Mr. King did, that he could protect these people from the clutches of the law if they burned a church down. Butler believed that he could receive jury nullification if he just showed up and explained his beliefs to this jury without regard to what it was that they did or what it was that he did, negligently or intentionally or otherwise. He was confident until the very end that he was going to prevail simply because he was a Nazi and provided a service to the community to cleanse North Idaho and by extension the Inland Empire of blacks and Jews and Hispanic people. And he was going to rely on this jury verdict, the first one that of this type that Mr. Dees would have lost. He was going to use that as a cultural flag or a cultural semaphore or as a cultural marking place for his popularity and the value of his beliefs in this local area. And Richard Butler and I are alike in this. Richard Butler and I are cultural politicians. When I'm not practicing law and I'm not tending to family matters, I'm a cultural politician. And cultures do not talk back to you in any regular way or any form that you can understand readily. If you're a politician that stands for elected office periodically, you know how you're doing because the law says you have to stand for election every 2 years, 4 years, or 6 years, whatever your term of office is. And somebody runs against you and says you're a scoundrel, and then you say, no, I'm a wonderful person, and then there's a vote. And you get to find out what the people say. In cultural politics, it's much more subtle than that, and it's much more sophisticated, and it's much more important in a way. It's because it's out of the culture of the community with which elected politicians grow. The seed corn, or the earth with which elected politicians grow, is the soil of culture. And so cultural politicians prepare the soil for the elected politicians to come and plant their little ideas and their little campaigns. He and I, Butler and I, are on opposite sides of this. And he says that North Idaho, and by extension the Inland Empire, were culturally racist because we're all white, essentially all white, and that we aggregated here for racist reasons, and that he was here to ensure, to lead us into this new millennium of racial hatred and of all white existence in this pocket of America. The task force, which I belong to as genetically now, it's been so many years, and by choice, said the opposite, that we are American citizens first, primarily, and always, and that the politics of exclusion and the politics of hatred are not primarily the politics of America, that the politics of America is equality and diversity and union and sharing and affection for one another, and that's the politics of America. And this other process is foreign to us, and that these people are in fact Nazis, as I've made that point earlier. So what do you do with a trial like this? You get a $6 million verdict, 12-0. It's one of the largest jury verdicts in the history of the state of Idaho. What do you do with the verdict like that? What you do is you argue that this was the culture's way of speaking not only to the task force and not only to Richard Butler, but to the nation at large. And that jury verdict, as a cultural window, as a way of looking at society, said to us in this most eloquent way, Richard Butler, you're wrong. The politics that you practice are wrong. The crimes you commit on our behalf essentially are wrong. The shooting of this poor Mrs. Keenan and her son is wrong, and the mugging of them is wrong. And this drunken paranoia that invaded this 20 acres of land in North Idaho was wrong. And that there was these actual damages of $250,000, and then there was these punitive damages of well over $5 million. And they knew, this jury knew, that there was only roughly $250,000 worth of property in all of the hands of all of the defendants aggregated together. But they returned a verdict of $6 million with the punitives and things like that all added in, as a way of expressing the culture of North Idaho in a true and Bell-like fashion. And it was that verdict that we have used for our own purposes as a flag or as a semaphore or as a window into our culture for anybody that cares to view our culture in an objective fashion. And they can't subtract the zeros from that, and they can't add zeros from that. It just exists as a truth by itself, and it's a tremendous advantage to us. So they say war is politics in another form. Lawsuits are politics in another form when viewed that same way, and jury verdicts are politics in another form. And nobody should leave here without understanding, and young law students that are here should not leave here without understanding that as they practice law, in a way they're practicing politics, particularly in lawsuits like this. Deep, serious cultural politics.
And now I have some questions for you. The First Amendment guarantees the right of free speech. By curtailing the right of an individual to express with vitriol that which one hates, are we not violating the First Amendment?
Let me say a couple things about, I think the answer is obviously no. I think, these cases really don't have much to do with the First Amendment at all, in my view. There's criminal incitement, which is quite a different matter. And my understanding, from talking to lawyers at SPLC of criminal incitement is, there is essentially this huge difference between saying, say, all police officers ought to be killed, and saying in an excited situation, quote unquote, in the middle of a demonstration where it's us against them and the cops are over there, you, George, ought to go over and kill that cop there. That's criminal incitement, or arguably criminal incitement. It's quite different. Really, though, the reason I jumped in is I just wanted to point out I've been to Europe a lot in the last 4 or 5 years because we are certainly not alone in the United States in having a really quite resurgent radical right and real problem with neo-fascism and neo-Nazism. And I'm sort of here to tell you that the Europeans almost universally regard us as mad, out of our minds, for not criminalizing speech. I hear this again and again and again. As a matter of fact, I remember being at a particularly kind of large conference on all of this in Stockholm and being attacked, really rather viciously attacked by the representative of a French anti-racist group, who actually stood up in this giant conference and likened my position to being, which was in defense of the First Amendment essentially, as being like a Nazi. And I tell you that just for interest because it's a fact. And Canadians also criminalize speech, although to a much lesser extent than most of the Europeans. Of course, this is strongest in Germany, where it's actually constitutionally prohibited to Sieg Heil, to deny the Holocaust and those kinds of things.
I would like to close this 12th week of our special series on confronting hate by thanking the panelists that were on this program. And I also want to take time to thank KSPS Channel 7 in Spokane. During this week, we had programs at North Idaho College and Gonzaga, and Channel 7, or KSPS, was very gracious and cooperative to do the taping at the Gonzaga campus so that we could have those programs to share with you. We've had a very long affiliation with KSPS in Spokane, and we're very grateful for that relationship and thank them for the extra time they put in to make this possible for us. Next week, we will turn to yet another issue, and I hope you will be with us at that time. Until then, please have a good week. I am Tony Stewart.